Welcome to this fourth video on the principles of international arbitration. I will continue the explanation started in the previous video on the main principles of international arbitration. In this video, we will more specifically consider how arbitration is agreed upon. How do the parties agree to arbitrate a dispute? What should the parties include in an arbitration agreement? These are the main questions that we will be addressing together in this video. As explained in the previous video, the principle of party autonomy implies that it is the parties themselves who define which issues are to be settled by the arbitral tribunal and which law the tribunal should apply in doing so. An arbitral tribunal, as a legal dispute settlement method, should base its decision on legal principles, in sharp contrast to historical examples in which the Pope or a foreign sovereign decided a dispute more on diplomatic and political considerations. Therefore, the identification of the applicable law is important and should be given careful consideration. In practice, the applicable law usually is determined in the arbitration agreement, to which I will revert in a couple of minutes. The choice of which law the tribunal should apply depends largely on the type of dispute which the parties submit to the tribunal. In the case of an interstate dispute, the parties will generally ask the tribunal to apply international law. In doing so, they are free to ask the tribunal to apply a specific convention or conventions. This was the case in the Mox Plant arbitration between Ireland and the United Kingdom under the Convention for the Protection of the Marine Environment of the Northeast Atlantic, the OSPAR Convention. The OSPAR Convention itself contains a provision which asks any arbitral tribunal established under that treaty to primarily apply the OSPAR Convention itself and international customary law. Parties are also free to ask an arbitral tribunal to apply soft law norms. I already pointed to the Alabama claims arbitration in the second video, in which this was the case. In the case of an investor-state arbitration, the parties usually ask the tribunal to apply international law coupled with domestic law. This is so because, as we will discuss in a later module, investment disputes require sometimes not only the application of international law, but also the principles of the domestic law of the state where the investment was made. If the parties fail to identify the applicable law, the tribunal will itself be able to do so. Most arbitration rules grant this power to an arbitral tribunal. Examples are Article 35 of the UNCITRAL arbitration rules and Article 42 of the ICSID Convention. A tribunal generally is prohibited from deciding a dispute based on equity, often called ex aequo et bono, unless of course the parties have explicitly asked the tribunal to do so. Otherwise, an arbitral tribunal should decide a dispute only based on the law as defined by the parties. This brings me to the last, but without doubt not least important feature of arbitration, that is, how an arbitration agreement is concluded. I should stress here the importance of an arbitration agreement. In international law, states have no obligation to submit disputes to a court or tribunal or to an arbitral tribunal. This fundamental principle here is that states need to consent to settlement by legal means and thus to international arbitration. This is a fundamental principle of international dispute settlement on which many of the principles already discussed derive from. There are generally two ways of consenting to arbitration. A first and originally most common way is to sign a special treaty in which the parties decide to submit an existing dispute for settlement to arbitration. This is called a compromis, special agreement, or more specifically for arbitration, an arbitration agreement. The second and now more common way is to include a provision in a treaty that deals with a certain set of issues in which the parties agree in advance that any future dispute that may arise under that treaty can be submitted to arbitration at the request of any party. This is called a compromissory clause. In both cases, however, it is important that the agreement contains the necessary information on how the arbitration will be conducted. Indeed, as I have explained before, the parties are free to determine this themselves, and therefore to avoid any ambiguity or disagreement, it is fundamental that all issues just discussed are regulated in the agreement. The reference to a set of procedural rules or a detailed explanation of the procedure itself, the subject matter of the dispute, the composition of the tribunal, the applicable law, and so forth. I will finish this video with the last principle. When a tribunal has been established, the so established tribunal is the sole judge of its competence and the limits thereto. In other words, once established, the tribunal will itself decide whether it is competent to hear the dispute. This is called the principle of compétence de la compétence, another legacy from the J Treaty arbitrations. In this video, you have learned the importance of the applicable law as contrasted to a decision based only on principles of equity. You have also learned how international tribunals are established and which elements should be included in such an agreement.